story of Dan and Denise Sterling is a prime example of why PLF created the Coastal Land Rights Project. For 14 years, the Sterlings and their 4 children have been living in a small mobile home while they try to build a more permanent home on 143 acres of land they own in San Mateo County, California. They got all the necessary permits to build their home from the county, but then the California Coastal Commission stepped in.
We started the process of building one home, which was going to be just a single-family residence, and that obviously took longer than we had expected. We actually thought we would build in this area where we're standing today, and actually over the years had moved the house multiple times in order to meet, specific requests from the county. 2 additional children later, we're still arguing about certain things, and basically have continued from there.
The Sterling land has never been a farm or a ranch in the past, and it wasn't being farmed when they bought it. Yet when they applied to the commission for a permit, the commission demanded that the Sterlings agree to actively farm 142 acres and give the state an easement making this permanent in order to get their home permit. So we took the commission to court, and the court threw out this outrageous requirement, saying it was unconstitutional as a taking of private property.
I think the other thing that really kept at least me going, and I don't know about Dan, is just the fact that when you go and you sit in these courtrooms or you read these briefs, that they actually had the ability, or thought they had the ability, to take something that wasn't theirs.
The court gave the commission a second shot at coming up with a fair condition, though, but this time the commission required the Sterlings to dedicate all their land as open space. We told the commission we'd take them to court again, and the commission basically said, go ahead. So we did.
One year kind of creeped into another year, and we just kept seeing the light at the end of the tunnel, but it kept moving.
And once again, the court told the commission that it was violating the United States Constitution. It is outrageous that the commission was demanding that the Sterlings give the state 142 acres of their land to mitigate for a home that's going to be on less than 1 acre. And the court indeed found that the commission's actions were grossly disproportionate and flatly illegal.
I have no idea what is behind them, or why they would take a stance. They're really not gaining anything. I mean, to waste all their resources on fighting over one house or trying to lock up one piece of property indefinitely, I just don't understand it. They could be doing some great things, I think.
This whole process has been terribly unfair to the Sterlings. They've been trying to get a permit for almost 15 years. And the day I called them to tell them about their second victory, they had actually moved elsewhere so they could have a real home. This was all because the Coastal Commission wouldn't give them a permit for a home on less than 1 acre without taking all the rest of their land.
We finally got to the point where, having 4 kids and, 1,000 square feet and all of their stuff, it just got to the point where it was, unbearable. And as Dan said, a year turned into 2, turned into 3.
Thankfully, though, they are now free to build their dream home.
Hallelujah, it's finally nice to actually have some help and somebody who's on our side and can understand our story. It's been awesome.
PLF exists to help people like the Sterlings. That's why we dedicate resources to our Coastal Land Rights Project. We invite you to join us.